Every day, new scientific advances are made, but we live in a country where a judge and jury's verdict should be the final word. How do we decide what cases should be re-explored, and when is it right to second-guess our justice system? At what point should our elected officials step in and override the courts? Tonight, when justice and science collide. I'm Ernie Manous, and this is Houston 8. December 1991. Cameron Todd Willingham's home bursts into flames, killing his 3 young daughters. August 1992. Willingham is convicted of murder, due in part to expert testimony that stated that the fire was set by human hands. January 2004. Willingham's appeal for clemency meets with no response from both the Texas Board of Pardons and Appeals and the governor's office, even though fire investigators have started coming forward stating that there was no evidence to indicate arson. Starting in 2004, national media outlets published stories that bring into question the forensic evidence used. 2008, the Texas Forensic Science Commission begins examining the Willingham case, hiring fire expert Craig Baylor. Fall 2009, Governor Perry replaces all 4 of his appointees to the Forensic Science Commission, in effect canceling the hearing and leaving in doubt whether Baylor's findings would ever be heard by the commission. Baylor states that the claim of arson could not be sustained by modern science. Did the state of Texas put an innocent man to death? Could earlier use of advanced forensics have changed this outcome? Catherine Green Burnett, board member from the Innocence Project of Texas and Associate Dean, South Texas College of Law. And Sandra Thompson, Director, Criminal Justice Institute, University of Houston. Welcome to you both. First of all, after watching that story, and I'll start with Professor Burnett, should we be alarmed?
Yes, absolutely.
Why?
When we're talking about science and justice, we sometimes divide them as though a jury's verdict is so sacrosanct, so important, so without question that we can never go back and look at it again. But when we think about science cases, I think we should think about them as coming up in any one of 3 ways. Sometimes you have good science, but you've had bad scientists, bad results because somebody's made a mistake. Sometimes you have stuff that's called science that really isn't science. And sometimes you have good science that becomes better science as technology advances. And I think in every one of those cases, the right thing for society to do is go back and look at the conviction. Did we get it right?
Well, I mean, I think that's right. And if the question is whether, this is alarming, of course it is. If there are ever allegations of wrongful convictions, we know now that in too many cases, the system does make a mistake, and the worst tragedy of all is the thought that we execute someone who's innocent.
Now, our job today is not to retry the Willingham case, and we don't mean to be doing that here. But what is interesting to us is all of the surrounding issues that have come out of this one particular case. Mm-hmm. It involves the governor. It involves expert testimony. It involves forensics. It involves eyewitness testimony. All of these things that in some way I think we come to just assume are going to run smoothly. If you are accused of a crime, that all of these things will come in line, and if you did it, you'll be proven guilty, and if you didn't, you'll be free. But that isn't always the case. And we're seeing in a case like this, there are serious ramifications from it.
Well, that's certainly true. And I think, in Texas, we have at the moment, I think, something of a rebirth of our criminal justice system. I mean, we've really had quite a bit of shakeup in the state and across the nation because of innocence projects and wrongful convictions that have been established, where we are going back and rethinking our processes. And the Forensics Commission is one example of that.
Let's talk a little about those folks, because they're in the center of all of this and what's going on. And I'm not exactly sure I'm clear on all of what happened there. But that there is this commission that's been set up, and it was set up by the Texas government, Texas state government, to check into misuse, wrong use of forensics, correct?
Correct.
And different people were able to put different folks on this panel. I'll let either of you take it from there.
Sandra.
Okay, in 2005, in the wake of the crime lab scandal in Houston, there was a bill introduced which was passed to create a new commission to investigate the use of forensic science in criminal cases. And so this commission was established by the legislature. It gave the governor 4 members that the governor could appoint: 1 prosecutor, 1 defense lawyer, and then 2 forensic experts from anywhere, any experts that the governor decided. Then the lieutenant governor and the attorney general were also given appointees. The lieutenant governor can appoint 3, and the attorney general 2. And each of those appointees is designated to be again, a specific kind of forensic scientist, professor from a university, a certain center in a different university. So you have people on the commission representing all the Texas public universities.
And they have certain term limits.
They have term limits of 2 years.
Or terms, I should say, not limits,
not
but
limits.
terms of 2 years. At the end of this 2 years happened to coincide very closely with the investigation of this case for the governor's appointees.
That's right.
So I guess they ended on September 1st of this year. So at the end of September, the governor decides to appoint new people in those positions.
Correct.
Correct. But he could have left the current ones that were there and already involved in this investigation in place.
That's right, and I think, that part of the recent controversy is that normally you would expect that he would leave them in place because they were in the middle of an investigation, which is their job, to investigate cases where there are allegations of some kind of professional negligence or misconduct in the use of forensic evidence. Normally you would expect the governor would keep them in place unless there was some sort of problem, some kind of issue. Mm-hmm. But he is within his authority to decide to replace them for whatever reason.
So, Catherine, why is this a problem?
I think, for me, what the problem is that the whole political nature of this and the feeling that it's political has become the story. And the story should be, should we be concerned about science and how is science used in criminal trials? The new appointees will have time to look at the report. They'll hold hearings or they won't. They'll issue an opinion or they won't. And we can criticize that when it happens, if there are criticisms to be made. But it's obscuring the bigger issue. And this is not just a Texas issue. It's a national issue. Under President Bush, Congress charged the National Academy of Sciences to study forensic science. And they came up with a scathing indictment of how we do forensics. And yet, across the country, we love forensics. As people, as citizens, we love forensics. CSI is one of the most popular shows on television week after week. And I think we all have that human nature tendency to say, wow, science is hard, but here's an expert who's come in and told me this. It must be true.
And I think the terminology of the name expert suddenly makes us assume that means the person is correct.
That's right.
But as people have told us before, and we all are aware of this, in any court case you have expert testimony on both sides, and it's often 180 degrees opposite of each other. So what is science? To me, science was infallible. This is what it is. So how can we have points of view within science?
Well, it's like Professor Burnett was saying, that if the science is done properly and if it's valid science, then it is science. And it's going to be hard to dispute, which is why when prosecutors bring forth DNA evidence in a case, for example, that's going to be awfully hard for a defense attorney to dispute. But there are different kinds of scientific evidence, and there's some evidence that's called scientific that may not really be scientific, actually.
I couldn't agree more. I think that's what really the nub is. Analytical evidence, things that are tested in a lab, chemically tested, like DNA. That has a different feel to it. It's analytical. You're testing, drug testing. You're testing the chemical composition of a substance. But some other science, then you have battling experts, perhaps, bite mark evidence, some fingerprint evidence, hair samples. That's subject to interpretation.
Okay, and if it is subject to interpretation, why is it allowed into court as expert testimony? Why is it not opinion? Why is it not
It is
logical
opinion.
thought as
Yeah.
opposed to expert testimony?
Well, it's expert testimony, but experts are specifically allowed to give their opinions. Because there are some conclusions that experts can draw based on their training. And so, we do ask them, even DNA evidence for that matter is not conclusive, actually. I mean, it's pretty darn close, but there's still an opinion there that there's a match. Mm-hmm. And again, the match only means that the defendant is, one of, hundreds of thousands of people who could possibly commit it.
Right, but you say that, but then I think about lie detectors. And those are not allowed because they're an opinion of how to read these results from the polygraph. So why is that not allowed, but forensics when it comes to fire patterns, which is once again the way somebody is reading the patterns they see in front of them, why is one allowed and not the other?
It's the clash of science and law, right? I mean, it's lawyers and judges, and ultimately it's a legal conclusion as to whether the evidence gets in or not. And lawyers and judges aren't scientists, and so we have to rely on the experts to tell us whether their evidence is sufficiently reliable or not. Now, some things like polygraph evidence, the courts long ago concluded was not sufficiently reliable to be to be admitted as scientific evidence.
But we expect courts to act as gatekeepers, to say, this is good science, this is bad science. Right. You're an expert, you're not an expert. Mm-hmm. I'm a lay person. We rely on courts to make that determination, and maybe we should shift some of the emphasis back to the scientific community.
And that's really what this commission reflects, I think, is the legislature creating a commission of scientific experts to review evidence in criminal cases and to give a retrospective determination of whether the evidence was properly used or not.
And so you could have protocols. What makes good science? There's standards, I think.
Do we not have those?
No, sir. Stunning. Most of the forensic science that's conducted in the United States is done locally. By local law enforcement, not even so much on the federal side. Mm-hmm. And there's wide disparities in local law enforcement agencies in terms of funding, training, what their lab protocols are. And so they're not industry standards that you can go in and say, this lab meets this accreditation requirement. Just the opposite of hospitals. Think about how hospitals have to meet national standards. Labs don't have to. Mm-hmm. And yet judges are being asked to make the determination, this is good science, this isn't good science. And we're not trained for it. That brings me back
to the Willingham case, which is there was a fire investigator who investigated with the tools he had at his disposal to do it. These newer reports that come out say, well, some of this information was known at the time, some of it wasn't at the time. But if we follow what you're saying, they're working with what they have, and there is no standard.
Oh, exactly. And in terms of arson investigation, I think one of the big challenges has been how are arson investigators trained? And for a long period of time, arson investigators were trained. Let's say you be the long-standing arson investigator, and I'd be the new kid on the block, and I'd follow you around, and you'd say, okay, Kathy, look at this pattern. This means this means that. It was on-the-job training by people who may not even have a hard science background. Later developments are more sophisticated. Now we actually have samples. So the Limehouse case is a great example where in an arson investigation case, they were able to burn the house next door that was condemned in a similar way to see what it looked like, what the remains of the house looked like after the fire. This set assumptions that people have been making for years on their head. So, wow, we thought when we saw this, it meant this particular thing, but now it turns out it means something else. We grow and we learn. Science is always evolving, and to say that we can't go back and look at a case when science has changed seems kind of silly.
Yeah, but there's some chronic problems. I mean, even within laboratory kinds of analysis, seriology and things like that. One problem, and I think it's come out a little bit in what we're talking about, is that we haven't had forensic labs that were independent of law enforcement. So, in other words, when we talk about the Houston Police Lab, that's a part of the police department. It's not independent. So the same folks that are pursuing a prosecution and who may have already arrested a particular individual have an interest in, their evidence being produced in such a way. And that kind of dependence, that lack of independence, is also a problem. And then you're not necessarily talking about people who have been trained in science. These are law enforcement personnel who, while on the job within law enforcement, go to some training courses. Mm-hmm. Right? So it's not necessarily the case that they went to college and studied science, and so you really have technicians who have been trained on the job as police officers.
I want to move a little bit away from that, but still in the same vein to say, but in court cases, there is more than just the forensic evidence. And in the Willingham case, there is a lot of testimony that comes out from eyewitness accounts, behavioral thoughts, patterns of behavior that are outside of whether or not how this fire started.
That's great. That's a great question, and that shows the power of science. When you look back at the Willingham, descriptions of the Willingham case at least, it appears that witnesses on the scene perceived events one way until the investigation focused on Willingham. Then they perceived that same set of events in a different way. So he was struggling to get back in the house. He was distraught. He was over-emotional. He was not concerned. There's a label for this in science, and startlingly, we've even seen this occur with fingerprint experts. They've been studies done. We tend to think of fingerprints as pretty conclusive, right? But that in the context in which an examiner is looking at a fingerprint, if you change the context, sometimes the examiner's results change. That's one of the things that science does, demonstrates the reliability and what's the error rate. Same thing will happen with people. You think you've seen one thing, and then as you get context and someone else becomes a suspect, you reprocess in your brain what it is you think you saw, and you come to different conclusions. It's a contextual bias. You find it even with scientists.
So then what is fact anymore then? How do we decide in a court case what we listen to?
Well, I mean, at the end of the day, it's the one reason that there's so much focus on forensic evidence is that it is in large part the case. Regardless of what impressions other people may have of the suspect's reactions, all of that stuff, it adds something, but it's not going to be enough. And what really drives the case is when you have an expert up there who says it's a match, or...
We've already said an expert could be wrong. The experts could be an expert opinion.
That's right. And juror attitudes about this kind of thing may be changing as we gain more awareness that the science is not always right. But really, what are jurors supposed to do if they get an expert on the stand under oath who has the credentials and who says, this is my conclusion, this is absolutely what happened? In most cases, what we see is that the jurors believe that expert, that science really does speak, and they think it's CSI.
So if you're richer and can afford the better expert, you're going to win your case.
Well, yeah, having a good defense team is critically important, and having access to defense experts is also important.
I want to go back to Willingham again for a moment and say, over the 12 years that he sat on death row, there were 5 appeals, and everyone upheld the earlier court's decision. This information about the flawed fire investigation had been coming out. I guess at one count, 7 different experts have investigated and all said, no, it wasn't arson. So if that information's coming out and these appeals are going on, why is nothing being overturned? To go to the governor's point of view, which we did invite the governor, and we did make quite a few contacts with his office to be here, and they could not send us a statement or did not send us a statement or let us have anyone to represent that point of view. But his point of view being the courts. It's been through the courts all the way up to the Supreme Court. Why should I change it?
Right. Well, I think one of the first things you need to look at is what's the function of the court at any given time, and that's part of what the National Academy of Sciences did. So the courts aren't the be-all and end-all. They can't be the right safety valve. It has to be in the scientific community. But if I'm convicted of a crime and I appeal my case, all the appellate court is looking at is, was evidence properly introduced at my trial? Is there sufficient evidence to establish my guilt? They're precluded, they're kept from being able to consider new evidence. That's not what our appeal process is. It's a very looking back, was the trial correct? And so you could have advances and changes in technology. That's what we saw with DNA. All of those convictions that have subsequently been overturned, and we use that term loosely, all of the people who've subsequently been exonerated, many of them went through the appeals process and their convictions were affirmed.
But if they had the DNA evidence while they were going through the appeals process, could that have been introduced?
No, there's not a mechanism for introducing that in appeals. You could perhaps on a writ, on another type of attack, but not on a direct appeal.
And there are very strict time limits for filing a writ on the basis of newly discovered evidence, what we call newly discovered evidence. If you miss those deadlines, and it may not be possible to meet the deadline because you didn't discover the evidence until years later, right? So it may not be possible. You're precluded. You cannot introduce that new evidence then.
Now, we talk a lot about the Willingham cases, though. An innocent man has been put to death because now there's yet another fire report that says that it was not arson. But the Corsicana Fire Department, I have a copy of it right here, has sent out and I don't know how many pages this is, going over Baylor's report saying that there is a bunch of errors in what he said. So that once again we're back for 21 pages talking about the errors in what we're all looking at, and the media seems to be saying is, see, it wasn't because, but they're finding errors in it too. When does this ever stop? When do you ever know what happened in that? Do we ever really know?
That's a great question. And I don't know. I think this is one that history will have to judge to a certain extent. I mean, we have to look at the credentials of the groups that are examining the case and make judgments on our own. I mean, and that's really what the Forensic Commission was about to do, right? That's what the Forensic Commission was examining.
And let me understand this too. We mentioned it in our setup piece. Because the 4 positions were reappointed, it stalled the investigation. Why did the investigation not just continue? Why didn't they stay on track even though these people are being replaced?
Too much stuff to read. They were replaced, September 30th for a hearing that was going to start
48 hours before.
The first week of October. If I were a newly appointed member of that commission, I'd say, please, give me a timeout. Let me read these reports. Let me study them.
Does that stop this from going forward, or does it just pause it?
Delays it.
It delays it, but there's a new presiding chair, and so, the agenda might change, depending on what the chair chooses to pursue.
But could the chair really, at this point, the way the national attention has jumped all over this story, say, we've decided this isn't important to look into, and they move on past it? Wouldn't the political pressure and the popular opinion be too strong to move away from this at this point?
I don't know.
I think that's anyone's guess. One would hope.
Yeah.
One would hope. And the court systems, as I say, they're not always the best place. And you said, when does it stop? My answer would be it should never stop as long as we continue discovering new science or as long as old methods come into question. It's never wrong. And I think about what we tell our children, what we want as a society about ourselves. We're none of us going to be perfect. We're none of us going to live without mistakes. And so what's the hallmark of a decent person or a good government? It's when you make a mistake to step back and say, wow, we made a mistake here. Let's own it. Let's take responsibility, and let's keep it from happening again. Because mistakes are always going to be endemic in a system that relies on science that changes, that evolves. It doesn't change so much as it gets better.
In addition to just the Texas Forensic Science Commission, Professor Thompson, you're on a new commission too.
That's right. The legislature recently established a panel. It's the Timothy Cole Wrongful Convictions Advisory Panel. And I was appointed to represent the Texas law schools on that panel. It's a diverse panel of state representatives, state senators.
That do what?
Judges of the Court of Criminal Appeals. Well, it's actually pretty daunting, because the idea is to study wrongful convictions and all of the kinds of problems.
Those that have already been found to be wrongful convictions, or potential wrongful?
Potential. More generally, what are the processes that are in place in the criminal justice system? What are the procedures followed by the police in investigating cases, in obtaining eyewitness identification evidence?
So kind of the opposite side of what the forensics group doing, or are they both together?
They're related, because we're also the Forensics Commission is really a place to take old cases and investigate the evidence that was used in those cases, where there may have been professional negligence or misconduct. This is really looking more prospectively at how can the legislature adopt new procedures or recommend procedures for law enforcement so that they do their jobs more in line with science, more in line with procedures that are going to prevent wrongful convictions.
So we're not giving up on our justice system yet. We're just going to refine it and get it to work best.
But DNA knocked us all for a loop. It really did. I think we all had a set. I'm a former prosecutor and a defense lawyer before I started teaching. We all had a set of assumptions that we can rely on the integrity and the validity of these verdicts. And then we discovered back in the 90s with DNA evidence that people had been wrongfully convicted.
We have to depend on time. We have no control over that, and we are out of it. Thank you both and for all the work you're doing, and I hope you'll come back.
Right.
Now, each week we invite you to visit our home online at HoustonPBS.org. Simply click on the local programs bar, pick Houston 8, and you can join our online community. Read about the guests, learn more about the topic, share your thoughts and ideas, and even suggest questions that we might ask during upcoming episodes. Remember, information posted on our website may be used on air, so keep that in mind when submitting. That does it for us tonight. Until next time, I'm Ernie Manous. Thank you for joining us, and have a great week.